In a ruling that hasn't received a great deal of pop media attention, but which could have seismic effects for business, could be appealed to the Supreme Court, and even as it stands, serves to help free people on the immediate level and serves to help people study the larger problems involved, a federal judge, June 17th, issued a preliminary injunction against a Biden administration rule forcing employers to provide reasonable accommodations for employees to obtain abortions, even in states where most abortions have been banned. Hi everyone, I'm Gardner Goldsmith for MRC TV, and here's the story. Michael Tennant reports for The New American, quote, "This is a textbook case of a federal administrative agency exceeding its statutory authority in a way that both usurps the role of Congress and violates authority vested in the states under the principles of federalism," declared U.S. District Judge David Joseph in the Western District of Louisiana. But Judge Joseph offers mixed insights there, and his words require intellectual, constitutional, and moral analysis. Working backwards on his statement, Joseph is correct to note that the federal government is usurping state authority, but he could note that the Constitution explicitly prohibits states themselves from violating the fulfillment of private contracts. So, if a state were to impose political mandates on what existing businesses and their employees already have agreed will be benefits, such as paid time away, then such state impositions would breach the contract clause in Article 1, Section 10 of the U.S. Constitution. Beyond that, one would have to check each state's constitution to see if states claim any power to issue such mandates on new businesses that don't already have agreements with employees, which also includes a wide array of other types of edicts, such as minimum wage mandates. And still deeper, one can acknowledge the reality that even if state constitutions allowed such impositions on private contract, such invasions represent aggression by third parties who have nothing to do with these private business contracts, and therefore they're immoral. And of course, the first portion of Judge Joseph's injunction also deserves scrutiny, because as we have seen with decisions such as the recent Supreme Court ruling on the Trump-imposed bump stock ban, Joseph correctly notes that such executive branch impositions aren't backed by legislation. But he incorrectly implies that if the Congress were to have included abortion in its 2022 expansion of the Americans with Disabilities Act, somehow that would have made the patently unconstitutional mandate perfectly fine. Tennant offers more of this background information for us. Quote, "In 2022, Congress passed and President Joe Biden signed the Pregnant Workers Fairness Act, PWFA. That law expanded the equally unconstitutional Americans with Disabilities Act definition of disability to include known limitations related to pregnancy, childbirth, or related medical conditions. Employers were thus required to provide reasonable accommodations for such a disability." And as Shakespeare might have said, "There's the rub." The problem Judge Joseph has with this federal mandate, this edict that businesses give women paid time off in order to have abortions, even in states that have banned most abortions, well, it centers on the Biden administration's unilateral expansion of that 2022 expansion of the ADA. So evidently, both the 2022 expansion committed by Congress and the 1990 George H.W. Bush era compulsion called the Americans with Disabilities Act are, to Judge Joseph, utterly constitutional and compatible with fundamental human ethics. Joseph Biden and most members of the legislative branch don't seem to care about the warning James Madison gave us regarding Congress misreading the Interstate Commerce Clause in order to claim power over any form of business going over state borders. They don't seem to care about the oaths they took to their Constitution. The matter at hand merely is one of parsing, of arguing over the semantics and minutiae of which kinds of offensive mandates the political marauders can impose, which is kind of like a trio of mobsters arguing over which fists they can use to pummel you. These tax-paid players are arguing over whether an abortion is medical care for a pregnancy. And though it is easy to see that such so-called medical care to end a pregnancy isn't care, some might argue that emergency abortion could, in a very, 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 very rare instance, save a mother's life. Well, none of that is relevant when it comes to the deeper, already established problem of the government imposing itself on private business contracts, period. Writes Tennant, quote, "The Equal Employment Opportunity Commission, EEOC, tasked with implementing the PWFA, decided that having or choosing not to have an abortion was one of the medical conditions related to pregnancy that employers would have to accommodate. The agency further declared that there were no religious exemptions to its rule and that it would consider any requests for exemptions under the Religious Freedom Restoration Act or any claims that its rule conflicted with state law on a case-by-case basis." Last month, Louisiana and Mississippi filed a federal lawsuit against the EEOC, arguing that, as Joseph put it, an administrative agency of the executive branch of the federal government without congressional authorization has exceeded its authority through the rulemaking process in a way that subverts the will of the citizens of Louisiana and Mississippi, who, through the democratic process, have banned abortion in their states in the wake of Dobbs v. Jackson Women's Health Organization 2022. In so doing, the EEOC has, at the very least, forced state governments to make accommodations for employees to do something those same governments may well have forbidden, end quote. Tennant also observes that in May, the U.S. Conference of Catholic Bishops, USCCB, and other Catholic organizations also sued the EEOC because they shouldn't be forced to give paid leave to employees who take time off to get abortions. And Tennant reports that Judge Joseph was very clear about this 2022 expansion of the ADA, this new statute called the Pregnant Workers Fairness Act, PWFA. Quote, "The PWFA, contrary to the EEOC's claims, incorporates the religious exemptions found in Title VII of the Civil Rights Act of 1964, Joseph found. Moreover, the legislative history unambiguously confirms that Congress specifically did not intend for the PWFA to require employers to accommodate abortion. Indeed, lawmakers from both sides of the aisle expressly stated that the PWFA does not address abortion. Emphasis in the original. PWFA sponsor Senator Bob Casey, Democrat of Pennsylvania, for example, said unequivocally that under the PWFA, the EEOC could not issue any regulation that requires abortion leave, nor does the act permit the EEOC to require employers to provide abortions in violation of state law. Now, this information is valuable for context and to give Americans an idea of what the current Supreme Court Dobbs ruling, what the PWFA, and what the extant Americans with Disabilities mandates already assume. But it does nothing to get to the root of the matter, which is the Americans with Disabilities Act of 1990 and its predecessors, the public accommodations portion of the 1964 Civil Rights Act and the 1946 Supreme Court decision in Marsh v. Alabama. The ADA hinges on the assumption in the 1964 Act that a privately owned place of business is a public place when it admits people from the public to enter. But that conflates the meaning of public and private. Public is that which is supported through taxation and opens a location to arguing by everyone who pays taxes because they have a justified claim over how that is going to be run. Private property is owned by individuals who don't force others to pay. They risk their own capital, and supposedly governments were formed to protect that property, not invade it and control it. And this is what has inspired all of this federal jerry-rigging from 64 to 1990 to 2022 to now Judge Joseph's decision. And this injunction will remain in effect until a final ruling on the case itself, and it will remain in effect as we get the chance to engage in scholarship to understand the forces behind all of this. Without engaging in such research and absorption of information, one can't spread the truth and protect freedom in cases such as this, as they inevitably move towards the Supreme Court and people get caught up about the abortion facet of it when they could look even deeper at the invasion of private contract and private property. Thanks for watching, everyone. Please like and subscribe. Find us, of course, on Rumble, where they don't censor us, and share the videos far and wide as often as you can, especially with people who are interested in these types of issues like constitutionalism, logic, ethics, economics, and private contract. You can also find us on YouTube, where, of course, yes, they sometimes still censor people. And you can find us all the time at MRCTV.org. That's MRCTV.org. While you're there, please consider donating to the Media Research Center. And, of course, check out the MRCTV Store for great, great items. And you can see what the whole team is doing at MRCTV.org. Open up a new tab while you have the opportunity. And feel free to find us on Facebook, on Instagram, on TikTok, and on Twitter/X. And if you want to find me on Gab, I'm at Gardner Goldsmith. And on Twitter/X, it's at Gard Goldsmith. Thanks so much for watching, everybody. For MRC TV, I'm Gardner Goldsmith.
I want to invite you as my guest on a very special, once-in-a-lifetime, 7-day post-election cruise in the Caribbean. It's going to be a blast.